study for you. Today, we're looking at a situation that hits close to home for a lot of families with adult children spread across different states. One executor lives 6 hours away, and the local co-executor is left in the dark, literally and figuratively. This South Carolina state involves a veteran who passed away, naming two of his sons as co-executors. One lives nearby, the other is about 6 hours out of state. What started as a straightforward probate turned into major property damage, security risks, and complete radio silence between the brothers. Now, we're keeping all the details fully anonymized to protect privacy in the attorney-client privilege, but the facts are real and they show some classic red flags any heir or co-executor should watch out for. So let's dive right in to what we got going on. Let's see here. Not sure we got. Yep, there we go. All right, very good. So like I said, I am not your attorney. This is most likely not even licensed in your state. So this is for educational purposes only. Every estate is different. Consult with a licensed attorney in your situation for your state in your situation. Results vary. No guarantees because it's probate and litigation. All right, so the case background. Like I said, the father was a veteran, passed away in mid-November. He passed away in mid-November, naming two of his sons as the co-executors. Getting ahead of myself here. There we go. As the co-executors. The will named the primary executor lived in Valdosta, Georgia, which is about 6 hours away. And the secondary executor, the son who called us, lives only about 45 minutes to an hour away from the family home. So it's much easier for him to go by, talk to the court, monitor the property, talk to contractors, whatever the case may be. The decedent had put both sons in the will as executors, clearly wanting them to work together. But almost immediately, things went sideways. The out-of-state brother took one of dad's trucks back home, 6 hours away, and took every set of the house keys with him. Meanwhile, the local son is the closest family member to the property, yet he has zero access. No keys, no information, no update on what's happening with the estate. The core problem here, fast forward a few months, and the house is in real trouble. A hot water heater in the attic exploded, causing major water damage. The local son couldn't get inside to check because he had no keys and no electricity or lights in the house, and he literally had to peer through windows in the dark to try and see what had happened. Meanwhile, the out-of-state executor was checking on things, using indoor ring-type cameras only, not outside the property. Neighbors later told the local son that strangers had been in the yard asking to buy items. The family car was ransacked, and an old RV on the property was left unsecured with just a key hanging there. Repairs? The insurance company sent a contractor, but the primary executor fired them for reasons no one understands. Sheetrock building materials have been sitting outside the house, exposed to the weather with only garbage bags protecting them. On top of that, the primary executor hasn't provided any meaningful updates or estate information. Misfiled the required inventory. The court gave him an extension, but he still hasn't properly submitted it weeks later. Sent the wrong address for the descendants' TSP, essentially retirement benefits, delaying that payout by 4 months, and installed a lockbox on the property, but refused to give the local son, his brother, the code. The son told us he's tried repeatedly to get keys and information, only to be told no or get vague responses. He has a strong feeling funds or assets may be being mismanaged, though he has no proof of that yet. The client had some very direct questions, and we hear them all the time in these co-executor disputes. Why won't the judge just give me the keys when I'm the closest one? Well, we explained as co-executors both have equal fiduciary duties under South Carolina law to preserve and protect the estate. Withholding access from the other co-executor is a serious red flag. What about the stalled repairs and fired contractor? Well, failing to promptly address major damage like a burst water heater can lead to even bigger losses. South Carolina probate law requires the personal representative to manage the estate prudently and in the best interest of all heirs. He keeps saying that he contacted the court. Is that enough? not when deadlines are missed and the local executor is kept in the dark. The court expects timely inventory filings and proper notice to all interested parties. The caller's bottom line: I just want this handled properly and quickly. I'm willing to apply pressure first, but if you won't cooperate, I want to step in. Here's our solution and what happens next. Here's exactly what we're doing for this family. One, step in and immediately request all estate filings, inventory, and repair documentation from the primary executor. Apply formal pressure through demand letters and direct court communication so the local executor gets keys, access, and full transparency. And if the primary remains non-responsive or continues to delay repairs and filings, prepare a petition to remove or replace him as personal representative, potentially naming the local son or a neutral third party to finish the job. And then finally, get the house secured, repairs completed quickly, and the estate moving forward so the family can close this chapter of his life. So there's another case study for you. The three big takeaways from this case study are: one, distance matters. An out-of-state executor who won't share keys or information creates serious problems and risks to the estate. Two, South Carolina requires personal representatives to file inventory within 90 days and to act prudently to protect the assets. Missed deadlines and ignored damage are grounds for removal and can get you in trouble with the court. I've actually seen some cases where probate court has issued arrest warrants for personal representatives that weren't following the law. And then number three, just lost my notes. Number three, co-executors are supposed to work together. When one stonewalls the other, heirs have a right to step in and ask the court for help. Pro tip: if you're a co-executor or heir, document everything in writing, texts, emails, and keep copies of every court filing. Don't wait until the house is falling apart. Get experienced counsel involved early. So that's today's real anonymous case study. These are the exact conversations we have every week and frankly every day with families to get probate back on track. If you're dealing with a distant executor, co-executor drama, or a house that's sitting vulnerable, drop your questions in the chat and I'll answer live on a follow-up or make a social media post. Stay tuned. If you're enjoying these probate case studies, hit like, subscribe, follow all the buttons you're supposed to hit there, and we'll be able to answer those questions, or you'll get updates on these case studies. And usually what I do is if you want to avoid probate and the headaches of co-executors and things along those lines, you should probably look at using a living trust as the basis of your estate plan. When a properly funded living trust is in place, it completely bypasses the probate process. And so it's much cleaner, much easier, much more streamlined process. So this has been Bobby Sawyer with our probate case study series. Look forward to seeing you on the next one. Thanks. Have a great day.